Thank you, Mike, and good morning, everyone. My name is Greg Porter. I'm a litigation associate attorney at Longyear. And with my brief time, we're going to go on a bit of a frolic into a different subject. I'll be introducing you to the principles and framework for insurance coverage and subrogation for personal injuries in Washington, as part of my practice is personal injury litigation. Now, the first step to understand subrogation are the different types of insurance that might be available. First and foremost is the liability or third-party insurance. And this is the insurance held by the person at fault. And legally, they are responsible to pay. But they don't pay until the case is either settled or reduced to judgment. And that's a process that might involve lawyers like me and take months or years. So what do you do about the medical bills that are piling up for the treatment you need now? And that's where the other insurers and the whole concept of subrogation comes in. Because other insurers will pay without fault, more or less meaning upfront, and then obtain an interest in the ultimate settlement. And the first in line of all of these is personal injury protection or PIP insurance. In Washington, this is usually a component of your auto insurance policy, since in our automobile society, most injuries that are not covered by workers' compensation will occur in cars, and they pay medical bills upfront and seek reimbursement at the end. And the next type of insurance is uninsured or underinsured, and that combined is UIM. Now, this is also a type of insurance held by you, the injured party, but they sort of act like the liability insurer. Is a general case that happens is, let's say you have 100,000 or more in damages, but the party who hurt you only has $50,000 with which to pay you. So the party at fault pays the $50,000, and then you take the remainder of your claim to your own insurance, UIM, and you ask them to cover the deficit. And the UIM carrier will step into the shoes of the party that hurt you. So this is an adversarial proceedings. Sometimes you have to take your own insurer to court to enforce the UIM policy. But it is a component of Washington public policy that auto insurance must include UIM coverage. So it's another source of payment for your injuries. Now, another option is general purpose health insurance, whether from a spouse, your employer, or the state health insurance exchange. And this is not specific to personal injuries like PIP, but for our purposes, it acts like PIP, as they will pay bills upfront without fault and then have a subrogated interest at the end. The one caveat being that oftentimes, if they know you have PIP, they'll make sure that PIP pays first. And only after PIP has paid its policy limits will your general purpose health insurance take up the yoke. Another potential provider is Medicare or Medicaid, so the major government insurance programs. Now, by law, these are secondary payers, which means that any other insurance that can pay must pay first, whether that's PIP, whether that's your own health insurance, whether that's any other source of funds. And this is where we're going to get into subrogation, because even though they're the secondary payer by law, sometimes the way the chips fall, they are actually the first to pay. Say, a catastrophic injury, someone's in the hospital, and the hospital just bills Medicare, knowing the patient has Medicare coverage. So Medicare pays first, even though they're a secondary payer. So how do you work that out? And that's where we get to the whole concept of subrogation. This big word I've been using all along. What does it mean? I'll quote some of this rosy language from our Washington State Supreme Court. Subrogation is an equitable doctrine, the essential purpose of which is to provide for the proper allocation of payment responsibility. It seeks to impose ultimate responsibility for the wrong or loss on the party who in equity and good conscience ought to bear it. So how does that really work? Is the responsible party ultimately pays, but another insurer, whether that's Medicare, whether that's PIP, whether that's Regents through your work, pays upfront and then seeks reimbursement. And this process has two steps. Step one being, does the insurer have the right of subrogation? And then second, if they pursue subrogation, what is that process? So turning to the first, the right of subrogation. And this right either comes from the contract, the insurance contract you signed, or is just a matter of equity based on Washington law. And virtually all insurance contracts in Washington that cover personal injuries are going to allow subrogation. I sort of just assume there's subrogation, because even if it's not in the contract, it's public policy in Washington that insurers have an equitable right of subrogation, including for personal injuries. And then for frameworks like Medicare and Medicaid, it's also baked into their laws, whether state law or federal law. And indeed, Medicare has a whole department dedicated to pursuing subrogation. Now, there is an exception to the right of subrogation, and that is the made whole rule, which basically says if you, the injured party, don't get fully compensated from the party that hurt you, the insurers don't get their full reimbursement, which I think makes total sense. Why should you have to pay them back in full if you, the person who got hurt, didn't even get paid back in full? And so you often see this in the case of uninsured or underinsured, is maybe even after UIM coverage is exhausted, there still might not be enough insurance coverage to pay all your bills. And so then the subrogated interests get wiped out. Or I've also been able to use this rule in negotiating with insurers for, say, a contested settlement. Is the defendant never admitted fault? Maybe there was a split in liability, so it was only a partial settlement. And then I'd say, well, Geico, my client didn't get paid back in full because the claim was contested, so you don't get the right to get paid back in full. And oftentimes that works. More money, more compensation for the actual injured person, which is always the goal here. Now, the mechanism of subrogation is by law, the insurer has a lien over the eventual judgment or settlement with the at-fault party. And so once settlement or judgment is received, then some money has to go back to satisfy that lien. But the insurer does not get dollar for dollar back. So take a typical case, there's PIP coverage of $10,000, and they pay all $10,000 to cover your medical bills after an injury. Do you have to pay them back $10,000 from the eventual settlement? No. In fact, you actually have to do math to determine the correct amount of subrogation that the insurer gets paid back. And each type of insurance will have its own equation, but we're looking at the equation for PIP insurance, since they're at the front of the line. So this is the one that comes up most often. So if we look at an example here, let's say it's a $20,000 total award for personal injury, maybe a traumatic brain injury, long-lasting, maybe lifetime effects, and then PIP insurance coverage of $10,000. And let's say attorney's fees were at a pretty typical contingent range of 1/3. So 1/3 of 200,000 is 66,600. And let's say attorney costs were about 3,000. Maybe an expert had to be hired. Maybe there were a couple of depositions. These costs might even be pretty low for a personal injury, but we can use them for illustrative purposes. So take the amount advanced by PIP, 10,000, and then subtract this sort of computation where you find out the percentage of the total award that PIP covered. So if the total award was 20,000 and PIP paid 10,000, that's equal to 5%. And so 5% times the total attorney's fees and costs gives you this number, 3,480 and change. And this is the amount that gets reduced from PIP's right to subrogation. So PIP gave you 10,000, and the amount you pay back is 6,516 and some change. So again, not dollar for dollar. And I understand for some attorneys, math sort of causes a fight or flight instinctual response. So what's really going on under the hood here is that PIP is pitching in for the attorney's fees. After all, you, the injured party, had to go get an attorney and fight the good fight in court. So it's only fair that they pitch in to cover some of the attorney's fees costs. And you run the math, it comes out to a little more than 1/3 gets deducted from the amount PIP gets paid back on their subrogated interest. Now, again, different types of insurance will have a different computation. Medicare especially is its whole own thing. There's the Center for Medicaid Services, or CMS, that has this really labyrinth algorithm to calculate the amount of subrogated interest they pay. I don't think the best scientific minds in the nation fully understand how it works, but in a personal injury case, it's something you'll negotiate with CMS to resolve. Now, with all these different insurers and all these different subrogated interests, as my goal as representing the injured party is to maximize recovery for my client and also minimize the headaches of going through this whole process. So this is a basic framework. It won't apply to every case because every case is unique, but this is sort of the basic framework for what insurer bills should go to first. And in my experience, if PIP is available, make sure that they're paid first until they're exhausted. As they're front of the line, they don't make a fuss. They cover bills, and as we just saw from the previous slide, they only get a fraction back of the amount that they pay. Next, I'd say is once PIP is exhausted, send medical bills to private health insurance because they're the most PIP-like out of all these different insurers. Again, they might require that PIP be exhausted, but once they take up the yoke, it's a very similar process, a very similar calculation. Next, if Medicaid is available, that's Apple Health in Washington, they get a statutory lien of reimbursement, but they're very easy to work with, in my experience. They're willing to cut a deal. They understand. So happy to work with them. And then finally is Medicare, because they get really robust federal laws for recovering their interests. Again, they have a whole department whose job is getting their reimbursement back. Now, sometimes it can't be helped because you'll see situations where the hospital will just bill Medicare first thing as they don't have my flashcards. But if that's the case, then what you do is once there is a settlement or judgment, pay these liens back in the opposite order. So make sure that Medicare's interest is resolved first and foremost, because they have what we sometimes say in the business, a super lien over any interest. So it's really critical that they get paid back, then Medicaid, then private insurance, and then PIP at the end. So I think I'm running low on time here. So here's a little summary card for everything we've discussed, who's legally responsible, in my estimation of the basic framework, who should pay first, and then who, in my basic estimation, should get paid back first. Thank you all very much for your time.